right, good morning. We're on the record today now for the 28th Circuit Court here in Oxford County. We're taking up two files. Each file is entitled People of the State of Michigan versus Nathan Douglas O'Brien. Two case numbers are 25-13990FH and 25-13991FH. Appearances from counsel, please.
Nate Carnes on behalf of the people.
Bill Burdett on behalf of Mr. O'Brien.
Thank you. Before the court also is Mr. Kevin Stubbleman. He's an agent from the Michigan Department of Corrections who is here today serving as the probation officer. And joining us this morning from the Wexford County Jail is the defendant, Mr. Nathan Douglas O'Brien. Mr. O'Brien, are you able to see and hear the court today, sir?
Yes, Your Honor.
All right, thank you very much. Just a minute, catch up on some paperwork, please. We're here today to address a request and summons for a probation violation that was filed back on October 15th of 2025. It included two allegations, both having to do with allegations involving failing to comply with the Sex Offender Registration Act here in the state of Michigan. And it was released on a personal recognizance bond, like on November 6th. The matter was set for an informal hearing initially on November 14th of 2025. And that was appointed to assist. Were you appointed or retained?
I was appointed, Your Honor.
All right, thank you. We also appeared on that 14th, and the parties each waived their 14-day rule underneath 6.445. And the court therefore had it set for a hearing. It was initially set for December 8th of 2025. And then it was reset after that for today's date. And that's why we're here. Mr. Carnes, you know what we're doing today?
Your Honor, I think the defendant will be pleading guilty. The people have agreed to recommend time served and continue probation.
Did he pick up a charge? I'm sorry, did he get a conviction related to this?
Your Honor, he's going to be arraigned on that today at 1:30. I have made an offer to Mr. Burdett on that file, although he's not technically his appointed attorney on that file.
And why is what's he in jail for?
Your Honor, he was picked up on the new charges, and I didn't know.
Okay.
I was been always in jail, so I didn't have a chance to talk to him about it.
All right, have you had the opportunity to speak with him today?
No, I didn't, Your Honor. And I'm going to be requested to be appointed on his new case, so we
All
can
right.
wrap that up then.
So we can do a couple things. Let's assume for the purposes of this next part that he ends up entering a plea guilty to one or more of these violations. The court could then give him time served, but does he really want a sentence today, or do you want to wait to find out what happens on the other case? We don't care.
This is his first SORA violation. The offer downstairs is for Killebrew to find the cost and this.
Okay, so theoretically, so we could also do this, Mr. Burdett. We can take a couple minutes and allow you some time to go into another room. Do you have a computer with you or a cell phone?
Yes, I do, Your Honor.
All right. Our next matter currently scheduled at 9:45, thus we have some time. And that is just a pre-trial and a show cause. So what we're going to do is we're going to take a recess here in place, allow you to use one of the other rooms, call into the Zoom. Do you have the Zoom number?
No, I don't, Your Honor.
All right. Mr. O'Brien, what we're going to do is make sure you have the opportunity here in a moment to speak with your counsel. Mr. Burdett's going to go into another room. He'll dial into the Zoom account, and then we will place the two of you into a private breakout room. And he'll come back and let us know when you're ready to go on the record if we're going to do so. You understand?
Yes, sir.
All right, thank you very much. We are present again. Mr. Burdette, how would the defense like to handle this today? Either set it aside, do a plea, it doesn't matter, just one.
My client's gonna be entering a plea today.
Okay.
Pursuant to the agreement, it's just gonna be fines and costs.
Oh.
And then I'll make myself available this afternoon to zoom in down in district court to resolve that.
Thank you. Mr. Carnes, does that sound accurate or what you understood we're doing?
Yes, sir.
All right. Mr. O'Brien, I'm now going to turn to you. Can you still see and hear me?
Yes, sir.
Thank you. Please raise your right hand. You swear or affirm that the information and testimony you're about to provide to this court will be the truth, whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. All right, Mr. O'Brien, I'm going to go over this again with you as it's been a few months. You are currently charged on a piece of paper that's called a request and summons for a probation violation. On that, you are alleged to have violated your probation terms and conditions in two ways. Count one alleges that you violated special condition 4.22. That condition requires you to comply with the instructions of your field agent. And more specifically, it's alleged that on September 30th of 2025, you had failed to comply with a written order from your field agent to verify your registration underneath the Michigan Sex Offender Registration Act. That is what's called a technical violation, and I'll explain to you what that means in just a moment. Count two alleges that you violated condition one. That condition of your probation requires that you are not to violate any criminal law of any unit of government. And again, it's more specifically alleged that on or about September 30th of 2025, you had violated Michigan law by failing to register with local law enforcement as required under the Michigan Sex Offender Registration Act. That one is called a non-technical violation. When there are technical violations, such as count one, the court is required to limited to any sentence or additional punishment to a sliding scale. For one count, for one technical, it's up to 15 days. For two technicals, it's up to 30 days. For three technicals, it's up to 45 days. For four or more, the court would no longer be limited to that sliding scale and would only be limited by the amount under the law. Similarly, for a non-technical, such as count two, the court is not limited to a sliding scale and is only limited to the amount allowed under the law. So far, do you understand?
Yes, sir.
In this file, you originally were convicted of assault, resist, obstruct a police officer. That is a felony punishable by up to 2 years and or up to $2,000. Therefore, it's a felony. Therefore, that sliding scale is the one I mentioned. Now, there's also another interesting quirk here is when a single act is alleged and could support two probation violations, the court would treat them as one because they are what's called the same transaction of events. In this instance, while it's listed as two counts, I'm required to treat them as one count. And it's a bit silly because no matter what, they're treated as non-technical, which means the sliding scale that I mentioned earlier would not apply. Now, if you plead guilty to these actions, allegations, you will not have a hearing or a contested hearing today, and the prosecutor, you would be waiving the right to have the prosecutor prove the allegations by a preponderance of the evidence, the right to question, cross-examine the evidence against you or witnesses against you, as well as the right to present witnesses, evidence, or testimony if you chose to do so. And of course, you'd be waiving the right to remain silent and not have that silence used against you. Do you understand that, Mr. O'Brien?
Yes, I do.
Now, there's another factor I want to make sure I cover, and I have no reason to think that there's any exception being played here by the prosecutor between he and Mr. Burdette and you. But if you make an admission here in a couple minutes, that could be used against you in the other case, which I'm told you're going to appear for an arraignment today. Any admission right now could be used against you in the other one, so therefore you'd be found guilty, if that makes sense. But I'm told today that you, through Mr. Burdette, with the prosecutor, have reached an agreement that will resolve that case today as well. And as I understand it, the sentence agreement would be that you would only receive fines and costs. Is that what you understood?
Yes, sir.
Knowing all that, do you still wish to enter this plea here today that we've already talked about?
Yes.
And again, as if actually I didn't say it, but I understand you're going to plead guilty to these 2 counts. Now, there's also some discussion here between the counsel, and that is they intend to make the same sentence recommendation in front of me on this probation file. In other words, there wouldn't be any additional time. You'd get time served. How many days have you been in jail right now, Mr. O'Brien?
1 day.
Is that just today?
Well, 2 days then. 2 days. This will be the second day.
Okay. Yep, all right, good, thank you. Mr. Stapleton, is that what you understand is going to go on and you're going to make that kind of recommendation?
Yes, sir.
All right. Have there been any other probation violations involving Mr. O'Brien in these 2 files?
No, Your Honor.
Oh, Mr. O'Brien, it was my failure. I forgot to make a note here. And I told you what the conviction was in file 13990, but I forgot to tell you what it was in 13991. 1 second here. Oh, well, this is a little more interesting. In the other file, 13991, you were convicted of a misdemeanor of larceny with the value of at least $200, but less than $1,000. Now, because that's a misdemeanor, and this is why I said it's a bit more interesting, in that file, when there's a misdemeanor, the court's limited to a sliding scale of 5 days, 10 days, or 15 days for your first, second, or third technical violation. But because there is a non-technical, it wouldn't be limited to that sliding scale. But it's my understanding that in both of these files, there's an agreement between you, through Mr. Burdette, and the prosecutor that there wouldn't be any additional jail. Is that what you understood?
Yes, sir.
Is that how you wish to resolve these 2 probation violations?
Pleading guilty.
All right, thank you. So, even though you said that's what you're going to do, I have to actually ask you. So here we go. As to the 2 counts of probation violations that appear in both of these 2 files, how do you plead, sir?
Guilty.
All right, thank you. One moment. To the file. The court takes judicial notice of the terms and conditions of probation that appear inside each of the court files. They were signed by me on June 9th of 2025 and subsequently acknowledged by the defendant. They were both dated the same date. All right. Mr. O'Brien, is it true that you had to register as a sex offender either through these cases or through some other case?
Yes.
And is it true that your probation officer told you that you needed to go get this done?
Yes.
And is it true that you failed to get it done in a time frame he told you to get it done, which means you didn't report to local law enforcement, such as the Michigan State Police Post here in Wexford County?
Yes.
Mr. Carnes, do you believe you provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, inducements?
No, Your Honor.
Do you believe that thus far I'm in compliance with the court rules?
Yes, Your Honor.
Mr. Burdette, do you agree with all 3?
Yes, sir.
Thank you. Are we able to proceed to sentencing, Mr. Carnes?
Yes, Your Honor.
Mr. Stapleton?
Yes, sir.
Mr. Burdette?
Yes, sir.
All right, I need to, before we turn to sentencing, Mr. O'Brien, I need to advise you that you have the right to be physically present in the courtroom when I give a sentence. That's how it works in every case. However, if you're willing to, you can waive that right and allow me to conduct sentencing right now. Do you waive that right to be physically present and therefore allow me to use the video technology?
I do waive that right.
Mr. Burdette, any objection?
No, sir.
I find pursuant to the Michigan court rules that it's appropriate to use the technology, and I turn now to Mr. Stapleton. Sir, your recommendation?
Thank you, Your Honor. The defendant was originally sentenced June 9th, 2025. Two dockets. The original sentencing guidelines were 17 months. He's done well and is actually in compliance now. He's has not had any problems with defendant at all. I recommend defendant be sentenced to 136 days jail with credit for 136 days and probation be continued and fines and costs preserved.
Mr. Carnes?
Thank you, Your Honor. This does appear to be the defendant's first SORA violation. I do take that seriously, but I also understand sometimes. Oh, I hope this is it, because obviously it gets. I will push harder on future violations, but it is good to hear that Mr. O'Brien is doing well on probation. I think it's a reasonable resolution today, so I'd ask the court to go along with it and impose time. So thank you.
Mr. Burdette?
Yes, Your Honor, I agree with the prosecutor. My client has fully registered with SORA. He's done well on probation. So we're just requesting you follow the recommendation this time. Mr.
O'Brien, is there anything you wish to say before I issue the sentence on these violations today, sir?
No.
All right, thank you. All right, well, I trust today the advice and comments from Mr. Stapleton. He normally is very open about probation performance by probationers underneath his supervision. And I accept that here today. I can say that other than this, I haven't seen Mr. O'Brien for the court. And again, sometimes I understand that it's interesting in the state of Michigan. There are differences of opinions, even within the Court of Appeals, Supreme Court, about whether or not SORA is a punishment or not a punishment. But I think it definitely has that impact, and it requires a person to go out and register. And sometimes doing that can be difficult, but he's overcome that through the guidance of counsel and the probation department, and he's now therefore in compliance. And there hasn't been any other violation, which is really quite important here, as I don't have an allegation of a new crime here before the court. So therefore, the court will accept the recommendations from the probation department. I think technically what I have to do is, one, preserve fines and costs, two, continue probation as previously set by this court, and three, I think I have to give 137 days with 137 days of credit to count yesterday and today. So therefore, that's the sentence of the court. All right. Mr. O'Brien, the next thing that's going to happen is in each one of these files, you're going to get 2 copies of a document. Now, you've already had this document before, but I have to give them to you again. You have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal, which only happens when someone's been convicted by a trial or at a trial by a judge or a jury. Because of the pleas in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want me to approve the appointment of an attorney, you may complete the bottom half of one of these documents and return it for each file and return to the court within 42 days. Now, again, I told you that you're getting 2 copies in each file. The first one, you're actually just going to put your initials on. Doing so neither elects nor waives any rights. It merely acknowledges receipt of the other copy. The other copy is for you to take and then return to me if you want me to appoint an appellate attorney, or it's for you to either put into a recycle bin or trash or burn or in an appropriate receptacle. I don't need it back if you don't want an attorney, okay?
All right.
You have any questions, Mr. O'Brien, about what we have done today?
Not at the moment, sir.
All right, good. Well, right now is the last moment I'm going to see you,
Last
so.
moment, so,
All right, well, I'm done with you. Anything further, Mr. Burdette?
No, Your Honor. Nate, I'll see you this afternoon.
All right.
Okay, thank you.
Is he on, so he's been arrested for the other charge, right?
Yes, Your Honor. He's gonna be arraigned today. I'm gonna see if I can appear by Zoom at 1:30 and
Okay,
get get an appearance and then we can wrap it up today.
all right, no problem. Anything else, Mr. Carnes?
No, Your Honor, thank you.
Anything else, Mr. Stuppleman?
No, Your Honor, thank you.
All right, folks, thank you very much.